Good morning. I'm Beverly Martin. I'm going to call us to order just a couple of minutes early, but I'd like to welcome you on behalf of the Center on Civil Justice. The mission of the center is to study the administration of civil justice and particularly to study how the civil justice system that we have now can continue to serve its purpose and maybe improve the ways in which it serves its purpose. I'm going to just tell you who our panel members are. I warned them that I'm not going to try to list all of their accomplishments because then it wouldn't leave any time for them to have their panel. So this morning, our first panel is moderated by Professor Colleen Shanahan. Professor Shanahan is a professor of law at Columbia Law School. She founded Columbia Law School's Community Advocacy Lab, and so she is involving students in making our civil justice system work better. And thank you for that. Next, I have Danielle Hirsch. Good morning. Ms. Hirsch is the principal court management consultant for the National Center for State Courts. She has a deep background in the workings of the Illinois state courts. So we'll benefit from hearing what she knows about how state courts work from that perspective. We also have David Udell, who runs the National Center for Access to Justice. The center's work includes the Justice Index, which some of you may be familiar with. It evaluates the quality of justice available in state courts across the country. The Honorable Lisa Jaskell is here. She is a judge on the Los Angeles County Superior Court. She's worked in a number of capacities to improve the experience of civil litigants in the state courts of California. I think the federal courts as well. Her work includes her path to the bench, I guess, includes her work with the Public Counsel Law Center in Los Angeles. So thank you for being here. We also have the Honorable Laurie D. Zeeland. She's recently left her position as an Associate Justice on the California Court of Appeal. She has served for many years on the California Commission on Access to Justice, including her time as the chair of that commission. And she's widely recognized for her work in the area of access to justice. And last but not least is Professor Lauren Sudial. She is a professor of law at Georgia State University College of Law. So she's kind of a hometown hero for me from Atlanta, Georgia. The program says she's an assistant professor. That's my fault. She is not. She's a professor there. And I know Professor Sudial's work in the field of access to justice in Atlanta, and she is, I can tell you, universally respected there and also beloved. So it's good to see you. And now I'll turn it over to you.
Thank you. Is this mic on? Yes, it is. So we're going to stay seated to sort of facilitate more of a discussion today. And I'm just going to kick us off, tell you a little bit about how we're going to try to have that conversation. So before I do that, I want to say thank you. Thank you to the Center for Civil Justice at NYU Law, to Beverly, to David, to Shirley, and to all the NYU staff who make events like this go off. We're deeply grateful to be here together and to be here with you to talk about state civil courts today. So this day is part of a growing conversation about state civil courts. That conversation is essential. It's essential for the 20 million people who have civil claims in state courts each year in the United States, the vast experience of civil justice in America. And as a result, it's essential for democracy, for how our country functions and where it's going in the future. So it's great that we're here today. And also, hardest things is to figure out what exactly we're talking about when we talk about state civil courts. Are we talking about consumer debt, or are we talking about child support? Are we talking about housing conditions, or are we talking about domestic violence protective orders? Are we talking about a form to help an individual litigant, or are we talking about restructuring an entire court system? So spoiler, we're talking about all of the above and more. And in the end, we have to figure out how to have these conversations. So we hope that today, the panel, starting with this first one that I have the great pleasure of moderating, will help us think about this essential topic and the role each of us can play and the things we know and the things we still have to figure out. So the way we're going to do this today is each of the panelists are going to make some brief remarks. I'll tell you sort of what each of us is going to try to tackle. And then the hope is we will open it up for conversation, for questions from all of you. And I, unsurprisingly, have a few questions of my own that I want to learn from these folks about. Luckily, Beverly gave us a little sense of who everyone is. So here's what they're going to try to do today. So David is going to kick us off, David Udell, and he's going to talk about data. He's going to talk about what we know and what we don't know empirically about state civil courts. And then Lauren Sudiel is going to frame some big conceptual questions for us. How do we think about the challenges? How do we think about the status quo of state civil courts? And what are the questions we need to answer to move forward? Then we're going to go from understanding the challenges to some potential solutions and hopefully get a little hope going with Danielle Hirsch. And she's going to talk about some of the ideas, some of the experiments that are happening on the ground in state courts right now. And then Judge Lisa Jaskell is going to take us to the ground, to the view from council table and from the bench about how these ideas and interventions are happening. And then Justice Zilon is going to talk about the collective work by the bench and the bar. So if we think about beyond a particular courtroom or beyond a particular court, what is it that we can be doing to change the systems that are part of the challenges of state civil courts? So that's the plan. Get your questions ready, make them hard ones. We're ready to have those conversations, and I'll turn it over to David.
Thank you so much, Colleen, and thank you for having us here at NYU. It's great to be back to my law school, and wonderful to be in this room talking with all of you about the civil legal system. I guess I want to start with like the headlines. I think the big takeaway is that we know so little about the civil legal system. We need to know so much more about it. We don't really have consensus standards for how to gather information about the civil legal system. And we don't really have reliable data. Where we do have data, and there's a lot going on right now to generate data, we don't really have a sense of its reliability very much. So I'll try to come back to these banner level takeaways, but I want to work through a few things that we do know. So I think we're all here partly, or when we talk about data, we're all here partly because Rebecca Sandifer, MacArthur, genius scholar in the field, wrote a study in 2014 about a medium-sized city and tried to figure out, well, how many legal needs do people have and what are legal needs, civil legal needs? And what happens when people have them? Do they go to the courts? Do they go somewhere else? Do they try to find a lawyer? And so her takeaways from that study were that experience with civil justice situations is common and widespread, affecting all segments of the population. Many involve bread and butter issues at the core of contemporary life, affecting livelihood, jobs, shelter, housing, or the care and custody of dependents, the big categories. Populations that are vulnerable or disadvantaged often report higher rates of contact with civil justice situations and a greater incidence of negative consequences from these events. Most civil justice situations will never involve contact with an attorney or a court, and that's something of a revelation. The most important reasons people do not take their civil justice situations to law are they don't think the issues are legal or consider that law is a potential solution. They often believe that they understand their situations and are taking the best actions that are possible. And then really the punchline of her study was the cost of legal services or court processes plays a secondary role in people's decisions about how to handle the civil justice situations that they encounter. So if you think about that, it's pretty big insight that it's not just the cost of a lawyer that's keeping people from asserting and defending their rights. It's other things that they believe about their situation. More recently, I think just last year, the Institute for the Advancement of the American Legal System completed a 4-year study with 10,000 people surveyed, really around the same theories that animated Rebecca Sandifer's 2014 report, and found that 66% of the population experienced at least one legal issue in the past 4 years, with just 49% of those problems having been completely resolved. On an annual basis, 55 million Americans experience 260 million legal problems. And of those legal problems, according to the people interviewed, 120 million legal problems are not resolved fairly every year. Those are pretty large numbers. While low-income Americans are particularly vulnerable population, the study also shows the need for fair resolution of legal problems is experienced universally across the different groups of populations. I want to note, because this is 5 minutes in broad brush, that the Legal Services Corporation, in its series of studies called the Justice Gap, essentially came to the same conclusions about the vast level of problems in the civil legal problems in the culture, in the society, and track how many people experience more than one problem, how many people experience more than 5 problems, and found similarly vast numbers. I want to shift a little bit from this question of like all the problems out there to the problems in the courts that make it to the courts, keeping in mind Rebecca Sandifer's observation that it's only a portion of the cases that make it into the courts. Probably the vast portion, she speaks of the iceberg and the amount that's submerged underwater, are those that are outside of the courts. But the data from the National Center for State Courts for 2020, which is a pandemic era period, shows 11 million incoming civil court cases. Now, they only surveyed 45, they only have data from 45 states. They're still trying to get every state to report just volume of cases. 3.6 million family cases in that 11 million number, 723,000 juvenile cases of various kinds. And then an additional 24 million cases in traffic court, some civil, some criminal. But I guess the point, particularly at NYU, where I went to law school, and I'm sure that the curricula here have evolved over the years, is that we're here to talk about the state courts, and we're here to talk about unbelievably vast numbers of cases that are in the courts, and even more monumentally vast numbers of civil legal problems that we don't understand well, that are handled for, as the European scholars like to say, lumped outside of the courts. I want to say a word about next. So we spoke briefly about the broad need. We spoke briefly about the number of cases such that we know. I want to say a word about the number of cases with lawyers and without lawyers in the court. So, you know, every now and then I have occasion to go looking for this number. It's impossible to find. There's no reliable data on it. There are estimates that are extrapolated from particular regional studies. Some of the scholars in this room wrote papers recently about lawyerless courts. And if you work through the presumptions they're relying on, it says that the available data suggests that 25% of state civil cases have a lawyer on both sides. That's a small number considering the rest of the 75%. In some areas of state court, like family court, nearly all cases involve 2 unrepresented parties. So no lawyers, lawyerless courts. In other areas like evictions and debt collection, one side may be represented. It's typically the powerful side, the landlord or the debt collection agency. That's the party that's likely to be represented better financed. So I want to shift gears. Do you know how many minutes I have? Maybe 0, but I'll spend a minute on my own work. And then I'll hint at all the other work that's being done, some of which I hope you'll hear about today. So at the National Center for Access to Justice, where I work, we have this project called the Justice Index. And I'm of the view that in recent years, the focus has usefully been on the human experience of the justice system. And that part of that focus on what are people going through and how many people are there is a product of the fact that we know that laws themselves are often not followed. But recently, there's a kind of shift in focus. I would say we've been part of it, and the Pew Charitable Trust is interested in it, and looking again at what are the laws and rules that govern people's experiences in the courts, and what are the laws and rules that might make it more or less sensible for people to go to a court. So we call it policy mapping. There are folks at Temple that call it policy surveillance. But we have tried in the Justice Index, which is an online website I encourage you to go to, so categorize what are states doing to make sure that their state court systems and other aspects of their state justice systems actually work for people. So what are the laws and the rules and categories that include access to attorneys, access for people with disabilities, access for people with language limitations, and self-help pretty broadly understood. We have a bunch of particular benchmarks that we track, and we actually have the temerity, although I'm pleased to say we're not the only ones in this room. Often I'm the only one who's busy ranking the states and irritating everybody. But I won't name names. I'm looking at you, April. We find that, so for example, we got a letter from a Western state this week saying, we really want to improve our language access score. We see in your Justice Index, here are 7 things we can do. What else can we do to make sure that we're providing competent language access across our state to people who need to be in court or want to be in court? To give you one more example, which is with informa pauperis waivers in the courts. Almost all the states have a provision to allow people to have their filing fees waived if they can demonstrate their poverty. But only a very tiny number actually direct court clerks to instruct people that you can file for a waiver of your filing fee. So I have a feeling I'm pretty much at time. The only thing I wanted to say, because I said I would hint at it, is that because there's so little data and such a need for data, we're starting to see fantastic projects evolve outside of the courts. I'd like to go on about the fantasticness of my own project, but I won't do that. But I will say that the eviction project, Professor Weary, who's in the room, who's starting to look at the numbers of debt collection cases and where they're occurring with geomapping. But also other institutions like the World Justice Project conducting survey work about people's experience of the justice system. The Academy of Arts and Sciences has had a big initiative to impress on the world the importance of focusing on the civil legal system and collecting data. The American Bar Foundation has been sponsoring research. Many of you in the room are part of that, to look at particular questions about what happens to people when they're in the courts and they don't have lawyers, for example, and what do judges do that's different than they would do otherwise when there aren't lawyers. So a million questions, lots of people working on it. You couldn't have said that 5 years ago even. Answers starting to surface, but I feel like George W. Bush now, or no, George Bush the first spoke like this in these clauses. So I'll just stop there. It's clearly a downhill slide, but thank you all for your time and attention.
Thank you, David. Lord.
I just want to echo Colleen's thanks to everyone who made this event possible. Thank you for having me here, and also to thank Colleen for shepherding our panel and what is a really wide-ranging discussion. So as she suggested, my goal in about 5 minutes, which is sort of laughable, is to try to describe some of the broader questions that at least inform my research and a lot of others' research, and that I think are really central to thinking about access to justice in state civil courts. I will not have a lot of time to talk about solutions, but hopefully we can, I know some of my panelists, other co-panelists will talk about that, and hopefully we'll get to that through our discussion. But I do think that these themes are really critical in thinking about reform, so I hope that we can keep them in mind as we have this discussion. So I've tried to group some of these questions under sort of the who, what, where, why frame. So the first category is who, right? Who are in these courts, who is involved and who should be involved. So like David was saying, we know some of this, but there's a lot we don't know, particularly about how the experiences of different people, how different people's experiences differ, right? In part informed by things like race and gender, because we just don't have a lot of access to that data on the civil side. So I think getting a better understanding of that, but also the role of different types of individuals. So the role of individual plaintiffs, for example, as opposed to corporate plaintiffs. And I know that people in this room are doing work on that, but I think it's important to think about how those differences actually impact the process. Who is making decisions in these courts, right? So obviously we know that judges are involved, but there are often other people involved, and also a lot more that we can learn about judges. So Sarah Green's doing some interesting research around judges without a JD. I think we make a lot of assumptions about the people who are involved and the knowledge that's informing this process that are not always true. In a lot of the courtrooms that I do research, there are no lawyers of any kind, the judge, the parties. And so I think understanding what the law or legal process looks like in those spaces is important. And also the role of other court personnel, right, who actually play a really significant role, particularly as David was saying, in terms of being able to inform litigants who don't have lawyers. Last, who is available to assist litigants and who should be available, right? So there are questions around the role of lawyers as opposed to non-JDs, the role of full representation as opposed to more limited forms of representation. So trying to understand the range of possibilities and also how those might impact the process. The next category is what, right? What belongs in these courts? We know, as others have already said, the vast range of matters that state civil courts handle, and also the numbers, right? That most cases in this country are in state courts. But I think, right, and Colleen and her, Alex Markle, you hear from later, and others have written about this. In a lot of ways, state courts have become the repository for a host of social issues, right, that they may not be sort of well-equipped or well-positioned to handle. And the reasons for that, we could spend more than one session talking about. But I think sort of acknowledging that and thinking about how these courts should be handling those matters, or right, whether this is the right way to be handling all of these matters, what actually belongs in state court and what does not. So I'm working on a project now that for now I've titled Delegalization, sort of trying to think about how we might import some of the ideas behind decriminalization to the civil sphere and sort of try to struggle with what seems like a crazy notion that perhaps there's a way to take some of these cases out of the system or to off-ramp them in ways that might be more effective for everybody involved. Where are state courts and how does place matter? I think I'm very sensitive to this as someone from a southern state, which are often not talked about in rooms like this. I don't know if there's another representation from that part of the country, but I think it's important to emphasize that regardless of region, right, there is no one narrative for state civil courts, right? Every state is widely different, and then within each state, there's a ton of difference. There's not one homogeneous block that we can talk about as if every court is the same or should be the same. There's incredible variability among courts and how they function. I know the Justice for All Initiative has really been, grapples with this as well. And even though state law might be the same, right, that there are vast differences in terms of the resources that are available, whether it's in terms of lawyers, what we all know about legal deserts, but also just the way that geography can impact courts and the people who actually navigate those courts, and local legal culture, the rules that develop and how courts handle issues. How do we know what is happening? So I know we could talk a lot about process and procedure, and others will talk about innovation that's going on in that space. Obviously, David's already spoken a lot about data. But I think in these courts, there are huge issues of data collection, management, and analysis. A lot of state court data systems are decentralized and really fragmented, making it extremely difficult to even get a picture of what is happening, let alone what should be happening, and how courts relate to one another. Another project that I've been working on is trying to think about, right, how court data is collected and structured, in the sense that right now, I think we've conceived of the way that court data is largely collected now as courts first, as opposed to what we've talked about as people first. So the idea being that right now, the question that we're asking rather is, what would happen if instead of thinking about sort of these questions through the lens of the courts, right? How many cases are being handled? What types of cases? Right, how many cases have been processed in a given point of time? What if instead we thought about those events through the lens of the individuals who are navigating the courts? So for any given person, what are the touch points that they have throughout the court system? How do those touch points relate to each other in terms of sequence, timing, interconnectedness? And so what we've tried to do in a pilot project is take data from a bunch of state courts in one system and try to restructure it so that you can view it through this different lens, which I think is really important, to just understand, right, what the system looks like from that perspective, but also to think about how we can make systems work better for the people who are in them. And the last set of questions, I think, relate to why, right? Why are state courts the way they are? Why are they structured the way they are? And what role do they play in sort of a broader access to justice or socio-legal context? As has already been mentioned, right, a lot of the time we spend, at least in academia, and I suspect elsewhere, is spent talking about federal courts. And even when we do talk about state court, we're often talking about criminal court. There hasn't been nearly as much energy and time spent really theorizing about state courts as a system, even though people have taken a deep dive into specific contexts, right, like child welfare, but thinking about state courts as sort of an institution, and sort of how they got to be the way they are, and right, what role they play. So just to provide one example, a recent article that I worked on with my co-authors is titled Racial Capitalism in the Civil Courts. And we tried to sort of engage with the idea that state courts play an important role in both sort of facilitating and perpetuating racial capitalism, both through the way that they interpret and apply the law, but also through the processes and procedures that they have developed and they administer. Right, and that's not to blame individual actors necessarily, but I think trying to be really thoughtful about the fact that these are not isolated incidents, they are part of these broader systems, and we have to be really thoughtful about, right, why that is and how we got there in part to actually change. So I think having thrown all of that out there, I will leave it at that, but I'm looking forward to discussing, touching on some of these questions through our broader discussion.
Lauren, Danielle.
All right, thank you very much. I'm really delighted to be here. So two caveats before I start. One, I'm an optimist, and two, I'm an institutionalist. And so I don't disagree with a lot of the criticism that people have about courts. And yet I think we're in this really exciting moment where there's innovation. And I think we see this innovation for three reasons. The pandemic unlocked a lot of experimentation and adaptation, and that extended to technology and rule and process improvements. There has been fantastic leadership. Many of them are in this room. And a willingness to work with and collaborate with community partners, so to situate courts within a larger context. So in my limited time, I want to focus on three buckets of innovation that make me really excited: process simplification, upstream innovations, and the thoughtful deployment of technology. So first, process simplification. What I mean by that is court systems were designed by and for lawyers. So typically we're teaching self-represented litigants, of which we've heard are very many, how to be like lawyers. Instead, I think in many instances, we need to change the system to meet people where they are and not try to teach them how to be lawyers, but teach them how to successfully vindicate their process or complete a case and get resolution. And we've seen a number of exciting examples across the country of courts doing this. So one of my very favorites is in the Alaska courts. They changed service of process by publication. So rather than having to put publication in a legal bulletin, which no one reads, let alone self-represented litigants, it's now on their website. So it's free, it's easy to do. I don't know how many people are regularly looking at the Alaska court website either, but at least we're getting closer to the intention of the publication in the first place. The second is an Illinois fee waiver form. It used to be called an indigency form or a 298B petition, both of which meant nothing to someone who needed it. So the form was stripped into plain language, and then it was changed so that if you receive certain kinds of benefits, which under the law guarantee you an automatic right to a waiver of fees, now you just have to check a box as opposed to then share all of your financial information. So it's really stripping the process to what it is intended to be. Another example is the great work of the Michigan Justice for All Commission, which is really looking at a bunch of key areas of law and seeing where are the areas where the law can be modified to meet people where they are. And the last, and this one is a little bit attenuated, but I hope you'll bear with me, is in Delaware, they're really taking a very hard look at how they regulate the admission of entry to the bar, to think about how they can increase their diversity of lawyers and change that process so that there are more people to represent people within the community. Okay, now on to upstream innovations. The first so by that I mean we're going not, as Lauren mentioned about the court is kind of hitting all these societal problems. Can we prevent the need for coming to court in the first place? So one is, I'm going to brag about our organization. The National Center has an eviction diversion initiative where we got $11.5 million. Our lead funder is the Wells Fargo Foundation, and we're giving funding to courts to hire facilitators to change the way eviction courts are handled. We have 12 courts currently in pilots from Alaska to Brooklyn, from Grand Rapids, Michigan, to Chattanooga, Tennessee, and they're really trying to change the way these courts proceed for the future. One court I'm particularly excited about is in Las Vegas, where we gave them about $1 million to hire 2 teams of 6 people, social workers, public benefits expert, legal aid lawyer, and a facilitator to really wrap around the court system and to meet tenants and landlords where they are throughout the landlord-tenant process and hopefully afterwards as well. We're in the early days, but I'm really optimistic about it. The second is a pre-filing medical debt pilot program in Chattanooga, Tennessee. It is early days there too, but it's exciting to see that courts are thinking about how they connect to the larger community and how they can play a role before a lawsuit has been filed. And the third I'll say is a dependency alternative program in Tucson, Arizona, where when there is concern of a dependency action being filed in juvenile court, the family is brought to court with any support systems and they try to resolve the underlying case and figure out temporary custody within 6 days. There's like an emergency response, and it's cutting down the need for these cases to drag on and for children to be placed in usually family care within 6 days as opposed to months of uncertainty. And then the last area I talk about is the thoughtful deployment of technology. And so as Professor Mark and lots of other people have done research, there are ways to do technology poorly. If you're simply just taking an existing process and you're adding a technological component, it's likely to fail. But we've seen a lot of examples of courts really embracing technology and process simplification all at once and really user-centered design. The first example I'll give you is the Kansas Order of Protection portal. It's a portal that was really aimed at the users. They used emergency federal funding to develop it. It has radically simplified the way people can apply for orders of protection across Kansas. The second example is in the Salt Lake City Justice Court. They use a buzzer system like you use at Chili's in order to come into court to hear your court matter. It may be really simple, but it prevents people from having to mill and wait in the court for a really long time if they don't want to. And it was developed by the local city council. Another example is the Miami Court Map program, which I'm sure Judge Bailey can speak at length about, but it allows you to have agency of scheduling your own hearing when you want. Small thing and yet profound and often doesn't happen, and developed a system that can be used regularly by litigants of all kinds. Another example is in Ohio, where they have launched a text reminder pilot program where they're funding courts across Ohio to innovate with different ways to use text reminders to remind people to come to low-level traffic court, where there is a huge number of failures to appear, which lead to a lot of collateral consequences. And then two things we're doing at the National Center. One, we developed a boarding pass, which is about expungement and sealing in Fulton County, Georgia. So the process of expungement and sealing in Atlanta is really complicated. This allows you to answer a series of questions, and it tells you only the information you need to know based on what you qualify for, as opposed to giving you traditionally a packet of 25 pages and making you determine what you're eligible for. And then we're working with Keith Procaro at Duke to develop a data gym to help courts understand what data they have, how they can share it with academics and others. And so with all of that, I am again delighted to be here, and I will cede the floor.
Thank you, Danielle. I told you she'd give us hope. Judge Jasko.
Thank you. Hello, and thank you for being here. I'm very happy to be here today. So I'm supposed to be, well, I'm going to try to give some information about what's going on at the ground level in civil justice. The main thing that I have to say today is the struggle that judges have in making sure that they're making sure that the litigants have a sense that they are being heard, that they are receiving justice, and the difficulty of doing that in a heavy volume court situation. So that's what we struggle with. It's always hard to make sure that everybody is having their input into the case, but it's certainly part of our job to do that. And so I'm on the Los Angeles Superior Court, which is one of the largest courts in the country. And there's always a heavy caseload in just about any civil courtroom. The court has taken steps to try to make sure that people are having their day in court. I don't know if Justice Seelan is going to go into some of these things, but self-help centers are very highly utilized in Los Angeles County. And those are put together with court personnel, together with personnel from nonprofit law firms in the county. There's also a higher use now of technology to help people who are representing themselves. So we have various kinds of document preparation technology that seems to be very helpful for people. But we are, especially with the pandemic, facing quite an increase in certain categories of cases. Domestic violence, you probably know, has increased quite a bit. So the judge is often faced with a courtroom of people who have very serious issues. And how does the judge hear each of their cases in a compassionate and informed and problem-solving manner? That's a challenge. But I have to say that I think that the judges in Los Angeles are doing their best to meet that challenge. And we are getting help, again, from some of the nonprofits. I happen to work in what we call our mental health court in Los Angeles. And recently, a wonderful nonprofit organization called the Mental Health Advocacy Services has agreed to work with us to provide support for the litigants and their families. And that's one of the main models that we have in Los Angeles County. We also, for the self-help clinics, I operated a self-help clinic before I went on the bench. They could provide a lot of help, and they do provide a lot of help. Of course, there are limits, and I think that probably some of the other speakers may get into how we assess whether a specific individual is appropriate for self-help care, whether that person needs more assistance. So I'm going to stop now and turn it over to Justice Seelan.
Thank you.
Thank you. And let me add my voice to the chorus of thanks for you for attending and for NYU for putting this program together. I want to talk about where the courts sit in a larger position. The professor mentioned user focus versus court focus, but in a way it is bigger than that, because the bar and the bench often feel as if they own justice, but we don't. The justice really is a community value and a community obligation. And so for real change to happen in the state courts, which is where more real people come than come to the federal courts, we have to be part of a larger community, I think. And that's where some significant work is going on, to look at the court and the bar in the context of not only administrative agencies, which meet people where they are, but also community groups, both legal groups and non-legal groups. So the social services community, medical programs, libraries, and religious programs. Because when you look at the people who have legal problems that they don't know are legal problems, or that they feel they cannot solve, they're going somewhere with their problems. They're talking to someone they trust. And often it is one of those community organizations. So if we are going to improve access for those folks, we have to put information and tools in the hands of those community providers who are the front line for so many people who have problems that may have a legal solution or may have legal ramifications. And there are a variety of ways to do that, but it starts with evaluating where people are going now and looking at how we can redirect them or provide services where they are. There has been a project that I've been privileged to be involved with for more than 5 years now, which is housed at the National Center for State Courts. My co-chair, Justice McCormick, is here with us today, and it's called the Justice for All Project. And the notion of the Justice for All Project was to take state courts and urge them to look at what their resources were community-wide, what their gaps were, and to evaluate in a very structurally defined way how to use the resources they have and how to manifest other resources to begin to solve those problems. There was some limiting funding from private funders that backed that up. And I will tell you that when we put the request for proposal out, 25 states, half the states, came forward and said, we would like to do a year's worth of work if you will give us, it was about $50,000. which to me spoke to the thirst for innovation and for understanding in the state court systems about how to expand the services that we can provide to people. There are currently 15 states who have devoted themselves to this process, who have done a rigorous evaluation and are piloting projects to come up with solutions. Just as a pitch, all of that information is on the National Center website under JFA, and you should look at it. But the notion that we were pushing courts towards is the idea of building a continuum of services. And the continuum of services is the idea that every person should get the help that is appropriate for them to get, and that they can get into the system in any manner, that kind of no wrong door idea, that wherever you go for help, you can find your way to the solution you need. One of the things I think that would make this process more effective is to begin to understand who needs what help. And it's a big problem for the reasons that have been identified. But what is the type of case and what is the type of person who can handle something on their own if they're given a little bit of information, all the way to who is the type of person and what is the kind of case where only full representation will result in a just outcome, and everything in between. So facilitated self-help, limited representation models, all of the things that we've talked about, more robust referral systems, so that if someone comes into the library and speaks to a librarian who desperately wants to help, because that's why people become librarians, the librarian can say, oh, you have this problem, here's who you can call, and not leave people out searching the internet for someone who might be helpful. So these 15 states and the District of Columbia are really the laboratories right now for this work. And it's incredibly important because at the end of the day, the state courts cannot serve the people who have needs without understanding all of these other resources and how the court can interact with those resources. Just so, as Judge Jaskell said, the judges can listen and make people feel that they have been heard and provide meaningful justice to them, whatever their situation. So I'll stop there, but it's a kind of outside view of what the state court systems can do.
Thank you. So I'm going to take moderator's privilege and ask a couple questions here to push each of our panelists further into the thing that I told them they only had 5 minutes to talk about. And thank you. Seriously, everyone should get an award for being a panelist who was able to keep to their time. It's a remarkable thing. So I want to, starting up almost exactly where you left off, Justice, I want to challenge the panelists to think about this problem, this value that I think we all agree on, which is the people who experience state courts as litigants, or maybe even not litigants, back to the study of legal needs, and our instinct that those people need to be part of our problem definition, part of our solutions, to hold more power in the process of shifting state court. So I think the terrific news is enough of us are paying attention to state civil courts that we've reached that understanding of a goal, but operationalizing it is incredibly challenging. And so I'd love to hear more, and I'm not going to call on people, you can jump in, although I'm a professor, so if people don't jump in, I will call on you. I'd like to hear more about, like, if we can assume away some of the institutional or maybe resource constraints, how could we shift this conversation so that a panel at an event like this has far fewer professors and judges and far more people who have been litigants in state courts? Or maybe even more, pushing it even further, we're not at an elite law school talking about these problems. We are somewhere else more embedded in the experience of litigating in state court. So what could we do? What are some bigger ideas about how we shift that power, how we shift that access?
All right, I'll start. I have a couple ideas. All right, I've got two of them off the jump, Colleen, and then I'll let other people. I think the courts need to make space and opportunity to engage with people. And Justice Elon mentioned it, Justice for All really provides a framework and an kind of asset mapping process that really encourages it. And in Kentucky, as part of that, they did a series of listening tours and I know they were not unique, Michigan did this too, and a bunch of other states. But I happened to go to one in rural Southeast Kentucky at a drug rehab center where a bunch of people just asked questions about what people's impression was or engagement with the civil justice system. And when they said that, no one raised their hand, no one thought they had engaged with the civil justice system. And then when we started to talk about like housing court or child support, then everybody's hand shot up and then we were off. And so just listening to people and understanding where they are, that was court staff, legal aid, from across the state, and they were going all over to different entities. And I think that thinking has since infused a lot of the programming and work that's being done in Kentucky. And in Utah, they're actually thinking about having, they have an Access to Justice Commission, and they have now 2 slots that are for people who've experienced the justice system. So that just like LSC does, really to make sure they're listening to people. So those are 2 examples, but it's a difficult and complicated question.
So I would jump in and say that I think it's illuminating to look at the criminal justice, I guess, reform / abolition movements, and also to look at the civil right to counsel movement, if you will. And the thing that sort of leaps out is sort of deep engagement of social justice organizations on the ground, demanding change. I think that work is hard to explain in a lot of ways. Why it's been so successful. I mean, I think we have to acknowledge, this is something I say as a more senior experienced person in the nonprofit world at this point, but we have to look at the important role of philanthropy in funding organizations across the country to engage in that advocacy. But we also have to think about, so how did the communications around those efforts become so sharp and so clear? On the criminal justice side, the legacy of racism, pre-emancipation, all the way up through Jim Crow into the present day, there's been a sort of through line that's been drawn by scholars and embraced by activists around how the current criminal justice system works and how it continues to perpetuate race bias in a lot of different ways. On the civil side, there is the recent racial capitalism piece, and there's some other pieces too, but it's really what I learned in the academy is called under-theorized. There's just isn't that much of an understanding of that. And there are a lot of people writing about it now, about how people are pulled in based on the color of their skin into the family courts, for example, to be prosecuted and investigated in neglect proceedings. But there's really, I think, a need, I don't know if others would agree, but I think a need to sort of bring all of that out. And then on the civil right to counsel movement, I just want to say that organizers have been funded to go out and engage with tenants and bring them to rallies. We have a civil right to counsel law in New York City, in part because the mayor, who was liberal but didn't feel he had the legitimacy to embrace civil right to counsel, was pursued at every public speaking event that he went to with like, what are you doing on civil right to counsel, with groups of tenants, with banners and attracting news coverage. And so I don't want to go on too long, but I would say that engaging the social justice community around messages that are understandable in particular categories of civil justice is maybe very important.
I think that going directly to people is an important way to do it. I mean, you asked about not just being at elite law schools discussing this among ourselves. In California, a number of years ago, there was an effort to really revamp the family law system, in which people are largely self-represented on both sides often. And one of the things that the group that was charged with doing this did was have a series of public hearings. And the people who came to the public hearings were not the lawyers. They were the people who had family law cases. And it was very illuminating to hear from them what they saw as the barriers and what they saw as the problems, and to use that to kind of begin to change the process to meet their needs. And I think there are a lot of ways in which we can directly reach out to the system users and ask them what they need, rather than thinking from our point of view about what they should need.
I would add a couple points. One, I serve, as I'm sure a lot of us do, on so many of these panels and discussions, and I often am struck by the fact that there is no voice from, that, although I don't want to assume that people on the panels haven't also had their own experiences, but right, I think it often does feel like that is a missing voice. Even like I remember on our Georgia Justice for All working group, I asked, why is there not anybody from these places that we're talking about actually here at this table? I will say from sort of a research perspective, I've done work where we've both collected data and done interviews, and we have tried to include actual people, both, for example, in the eviction context, landlords and tenants. Part of why, I know people here know this, that can be challenging, is because often the only way to actually accomplish that is to get people in sort of what is one of the hardest times of their life and ask them to sort of open themselves up to you when they've already just had this very difficult experience. So there's our real challenges, not to let us off the hook, but figuring out how to do that, and also in a way that's not exploitative, right? Can be hard to think about. But I will say, I agree with everything everyone said, but I think to the extent those of us are in the academy and do have access to students who will play probably some part in this system, I think while it doesn't get at, the issue of actually bringing other people into the fold, I think really trying to get students to internalize what that perspective looks like. So I co-teach a course at Georgia State with the deputy director of the center that I founded called Access to Justice Law Reform. And the entire point of the class is to try to get the students to really see, all of these systems. We touch on a number of different substantive areas. We touch on technology, on simplification, and to really try to get them to understand what all of this looks like. But we have them go observe court. A lot of our students don't spend a lot of time, right? Maybe in a clinic, but a lot of students don't spend any time in the courts where most people go every day. So we just say, go watch court, right? And I think for a lot of students, sadly, it's a very eye-opening experience, but we actually also try to have them craft a discrete reform that can actually be implemented by a nonprofit or by a court, and they present those to actual stakeholders. So I think it's a chance to at least get someone who may not spend their entire career, but should they go on to be, right, a lawyer, a judge, whatever the case might be, at least they will have had some time to sort of think about and discuss what that perspective looks like, even if they themselves, right, didn't have that perspective or experience.
Thank you. So I want to pick up on a couple pieces of this, and in particular, David, your explicit invocation of sort of abolitionist approaches to criminal justice reform, to ask, we heard in the initial remarks that there are parts of the challenges state civil court litigants face that aren't or shouldn't be in the courtroom, right? Whether that's social services, whether that's collateral consequences of the state civil court involvement, or simultaneously occurring problems. And so I want to ask the panel sort of two variations on a question. One is, are there things that we should be figuring out how to wholesale remove from the state civil courts, right? To systemic change. Are there just things we should be figuring out how to take out of the state civil courts business? And then a sort of corollary question, which is, are there interventions? Are there sort of potential solutions or small scale fixes that we should be rejecting because they're reinforcing the systemic problem? So sort of calling on that criminal justice reform way of advocating and thinking. Are there some parallels in the civil justice system? Are there things we should simply be doing away with?
All right, I'll start again. Sorry. I don't like silence. Okay, so if I had a magic wand and I could do something, I would fully fund the state courts from general revenue so that there didn't need to be filing fees. I think civil filing fees are, courts need them. I mean, it is the reality of how they function, but I think it really perverts the system, and fee waivers are valuable, but they only hit a certain percentage of people. Often a lot of working people don't have the money to pay some of those fees. So I would eliminate all of that.
Good one.
Yeah. Good one. Other thoughts?
You know, there's a problem with people preserving their records. And in some states, people have access to full records of their proceedings so that they do have the right to appeal. And I think the right to appeal is an important protector of people's rights. And, you know, in the criminal courts, I think universally the record is there. In civil courts, they're not. And I think that that's an issue that, again, in the fully funding part of the state courts, we ought to ensure that people have access through the full process. And that's an important aspect of it.
I think, I guess I would say there's the high level and then the sort of practical level, right? I think on a high level, I think we can't be afraid to try to think radically. Or this whole, when I teach that course I mentioned, we always talk about decriminalization, and I always ask the students, you know, might there be some analog to this? And the conversation never really goes anywhere because it's sort of immediately we throw up all these problems, which are real. And this piece that I'm trying to work on now, I'm trying to actually not let myself get stopped by those problems. But I think if you think about, in essence, what is happening with decriminalization, right? It's sort of the underlying issues or behavior are not going anywhere, but it's a societal choice to think about how we view that behavior and how we respond to it. And there's a number of different options, but we've just chosen one, right? And I also think it's a choice about what role we want the state to play in sort of policing individuals and communities. And so of course, this would require like all sorts of overhauls, but I think on a micro level, getting to the practical, there are ways just to implement the same ideas, whether that's sort of diversion programs or off-ramping, right? Imposing sort of heightened filing requirements to actually ensure that the cases that actually end up there are the ones that the courts are actually well equipped to handle, and the ones that aren't, we figure out a better way to handle them. So I think that there, and you know, you think you touched on some of those already, Danielle, and I'm sure people here are familiar with a lot of those. So I do think that there's a way to, the point I want to make, and I think what was interesting, this is a little bit of tangent, but related, in doing a recent research project around how local courts implemented some of the federal and state mandates around eviction prevention, so the CDC order and CARES Act, there was a lot of variation, and we did a project sort of trying to dive into how courts responded and also why they responded differently. But I thought what was interesting about that is that, you know, in the context of rental assistance, where there was this money given, we saw an exceptional amount of creativity and innovation in courts that I think are usually, and I'm not talking about state courts writ large, these courts are not usually that interested in that. So I think sort of where you are sensitive to, right, the things that matter to courts and what they need to do and sort of structure interventions that can account for that, you really can get a lot of innovation and creativity that I think, and we saw courts intervening pre-filing, right, to sort of try to, and so I think these things are possible, but it also requires thinking differently about the policies that we construct and how those policies are going to actually interact with these courts.
Well, I say one more thing, like many a ship has crashed on the idea of court unification, or the shoals. But I guess I would just say that, you know, through the work we do in the Justice Index, it's perturbing when you see that there's such a differentiation among the courts and such a lack of centralized kind of understanding of what is expected of every court across the state. And, you know, one of the judges in New York once told me that when the chief would send an email out to the entire population of judges in the state, that only about 40% would open the email. And so I feel like, you know, with technology, today we have a better shot at trying to rethink how the different parts of the state court systems relate to one another. One thing I saw in some states that I thought was interesting on language access, for example, is that even where you have really decentralized courts, you can use a website to post what's going on language access in every court. You know, it does each decentralized unit within the court system know what it's supposed to be doing, and is it telling the public on the state judiciary website what it is doing. So even where you can't unify everything, you can at least make more transparent everything. So I think there's room to revisit and hopefully not crash around the idea of more unification.
So I have more questions, but I'm also really curious whether you all have questions or whether there's information, perspective you want to share in response to this conversation, right? We've covered a lot. And so I think what I'm going to do is if you want to raise hands, I don't think is there a mic set up? No. So I'm going to, oh, there is. Okay, so there's a mic in that back corner. Oh, in that back corner, terrific. So if folks have questions or comments, if you wouldn't mind just going to the mic, that because we're on a webinar, we can pick up the audio and everybody can hear it. Thank you for playing along.
Hi, good morning.
Good morning.
So my question is going back to data collection and it seems like a lot of focus on data collection is on the state civil courts that are operated through state judiciaries. I'm wondering if there's also research going on involving administrative tribunals that are not through the judiciary, but through administrative agencies, for example, tax appeals, professional licenses like medical licenses or bar licenses, liquor licenses, things like that, that involve some measure of litigation, but are not strictly judiciary focused.
Would you mind
Thank you.
introducing yourself? Just we got you. So I
My name is William Lem. I'm an attorney in New Jersey.
Thank you. Thanks. Does anybody want to take this on? I can take it on too. All right. So I happen to have in some years ago done a big research project in an administrative court. So the answer is yes, and it's as complicated as state civil courts are as a data environment. So one of the things, a sort of unique variation on the challenges of administrative proceedings is whether the administrative proceeding is one that flows from a federal regulatory scheme or a state regulatory scheme. So if it's something, for example, like unemployment insurance cases, where there's a federal structure and then the state jurisdiction is implementing it, you've got a better shot at there being data to work with, just because of the DOL regulations and reporting requirements. Not 100% guarantee of success, but a better shot. Whereas some of the more sort of state level licensing schemes like professional licensing, I think is an example. It's really much more disparate. I think those of us, well, I'll give my view, which is I find administrative proceedings to have many, many parallels to the conversation that we're having here in state civil court, depending sort of on the subject matter. But generally, I think this is true. First, from the litigant perspective, there isn't a differentiation, right? Like I have a problem, I have to engage in a process, it has a particular consequence. Often that's affecting some economic component of people's lives. And so from the litigant perspective, it's all the same, but I also think structurally, many of the same challenges present. Certainly the absence of representation or maybe even any kind of legal assistance in terms of the sort of agency's court mechanism and the way hearings are conducted or information is provided to litigants. There are many, many parallels, and interventions like the ones that Danielle described often have had the same effects in agency proceedings.
I would just add that it's immensely important as an area for people in their lives. So for example, in New York State, whether you get a license to be a security guard is the difference between being in poverty and having a job or a low wage job. So it's huge. And I also think it's really interesting. A lot of the people involved in the access to justice movement have come out of the legal services benefits advocacy environment and have an awareness of the importance and the ability to sort of shape the system. And I'll say one more thing and then I'll be quiet, which is that in the administrative context, sometimes you have a clear mandate in the statute. For example, the Social Security Act has a mandate to, that it's a remedial act. It's designed in theory to get benefits to people who are eligible, and the administrative law judges have an obligation to develop the record, to tell people what the dispositive issue is, what the necessary information is, to try to go get it in an inquisitorial function. So I think we could try to import more of that back into the state civil court system. Now I realize the judges are already burdened in a million ways, so it's all controversial. But I think that there's room to model the administrative law access to justice movement on what's going on in the courts and back the other way as well.
Hi, I actually don't know how to hold this, but here, we'll try. Now it's sinking down. I'm short. Okay, my name is Janet Zabel. I'm a longtime legal aid and government lawyer in New York City. You all have raised such incredibly important things, and so I have lots of thoughts, but I wanted to start off by saying that I share with Danielle being like a hopelessly optimistic person, and so I approach this from that perspective. Colleen's question about expanding the conversation to include communities, my sort of question to you all is really to think about and what is going on, or to learn from you what efforts are going on to expand the community to the people who are currently working in the court system. Because I see great ideas and I see perhaps like individuals in different places who are really strong proponents, and even at the highest levels in the court administrative structure, but I don't see any possibility for making meaningful change unless you really find a way to have the court employees, and that's the judges, it's the court officers, it's the clerks, it's the whole range of court staff, to actually see that they share these same concerns.
The clerks of the court, I think, are an especially important asset in that conversation, because, the counter clerk is where the rubber meets the road when people come into the courthouse. And they are often asked to provide information that they don't feel they can provide, sometimes rightfully and sometimes wrongly, that there is information they could provide if they only understood how broadly they could act. But those are the people who see needs on the ground level. And, where there are court-based self-help centers is very effective when the self-help center is either co-located with or works directly with the clerks to understand the needs and to do the kind of cross referrals that you need. So I think that as these processes go forward, we need to bring those people into the conversation, as you suggest, but there are ways to do it. And I think some of the most effective court systems do listen to the people who have the most immediate contact, because as judges, there's the barrier. There's the bench, there's the rope, there's the barrier. But the court clerks don't have that. And so they have a deeper understanding than we do often of what some of the issues are that are confronting people.
But it does take often, at least I think, a leader within the judiciary to get the ball rolling. And for example, the clinic that I ran for 9 years, Justice Zelan put together a working group of lawyers, the clerk's office, to strategize a way to make sure that people had access and were heard and had their needs met. As the attorney who staffed the clinic, it also required the cooperation of the clerk's office, which I had. And so I think there's a lot of importance in the people who are in place and whether they can get the ball rolling.
I just have a couple of additional thoughts. Thank you for sharing my optimistic view. The first is building on what Justice Zelan said. I'm really bullish on the idea of what I call safe harbor policies, but court systems that concretize legal information versus advice. And the ones I like the best are the ones that define what advice is, and then they just list the kinds of things that you can do that are information, but say if it's not advice, it's okay. Because it liberates people. I think that having some permission is important, and you can use those policies then to do a lot of training of judicial officers and court administrators. And I think there's been a movement within judicial and court administration to be more holistic about who's getting that training. So judicial colleges that involve court administrators. And relatedly, I think the issue of referrals is an issue. Often the front line doesn't know what an appropriate referral is. So they'll send everybody to the bar lawyer referral, and there's nothing wrong with that, but there may be another provider, or maybe they know one legal aid provider. So they're sending everybody there, and it's inappropriate, and it's leading to a lot of confusion. And so there, I think, is a wonderful opportunity to work with local trial court administrators to train the front line on proper referrals. So we've been encouraging trial courts to have advisory committees within their court structure where they're hearing from regularly lower or court frontline staff or clerks' offices often who are in different departments to get good ideas and to incubate things.
I would just say very briefly that the access to justice movement, if you will, and the work of Jonathan Littman in New York, but also many other leaders of the judiciary across the country, has sort of brought up this idea of like, let's turn toward the sun, like let's focus on not just processing cases, but on assuring that there's justice. And I think that for better or for worse, in all states, there are people who have heard that sound. And we find in the work that we do to catalog policies across the country, every state, red or blue, there are very, very dedicated court staff. The only other thing I would add is there has been a self-represented litigants network organization headed by Catherine Alternator, which for the last 5 or so years has been a kind of outside of the system place for court staff, administrators within the courts to learn about research, innovative ideas, to participate in working groups on simplification and many other things. It's been fantastically successful substantively and as a networking phenomenon, not so strong in the fundraising, you know, so, and so we hope for its future, I guess is what I would say.
Can I just add, just really quickly. So I completely agree with the points around sort of legal advice. And I wrote a short piece suggesting that the way in which a lot of these provisions or prohibitions on legal advice are applied are probably actually unconstitutional. So we could talk about that separately. But I will say that I think your question is really important, and at least in a lot of the research I do that's mixed method, meaning that we sort of are collecting quantitative data, but also engaging in interviews and observation. For most of the projects I do, we really try to talk to everybody. So if we're doing a project that relates to court, you know, the judges, clerks, other court personnel, law enforcement who may be involved, you know, parties. And I think, you know, at least in my experience, especially even coming from Atlanta and doing research in more rural parts of the state, I feel like I've tried to really emphasize, and I'm sure I don't need to, you know, tell you this, but I think it's also really important to try to understand the perspective of the people on the other side. Because I think a lot of times as researchers or as people coming from a certain perspective, you can go into a situation sort of having an agenda or a sense of how things should operate. And we really don't go in with that approach. I think I know there's plenty of things that I cannot appreciate in terms of what this person is actually dealing with or the other forces that they have bearing on them. And I think that in our projects, we've learned a lot of information from the clerks, sometimes even more so than from the judges, because like was said, right, they are the ones who are often interfacing with parties who come in a very different way.
I want to just add 2 things. One is building what Lauren said. You know, I think those of us who do this research are increasingly and should do more sort of explicit identification of the role of clerks in what we're studying. And so what Professor Mark and I are years into a project that was supposed to be about studying judges, but more and more we're not actually writing about the judges because that's not where we're seeing the creative interventions, the real understanding of how cases are proceeding. And so I think the more, and Lauren's work is a great example of that. She's done, especially in the rural courts, I think that some of her work there has just really been illuminating. And so I think the more we do that, the more we're giving fodder to folks inside the system to say, wait, no, what I'm doing isn't just a special thing I do on the side, like it's actually my essential role and we need to pay attention to it and we need to motivate it. I'll also say there's and I'll reach a little bit here. There's a more political part of this that I feel really optimistic about. And I will, I'll say Justice McCormick is an example of this. I think the more that judges and folks within the court system see themselves as active political actors for whom it is appropriate to talk about structural change. And Justice McCormick's piece in the Yale Law Journal was sort of a full-throated call for this. I think that also will empower folks within the court system to create the change that really they're essential to. I see you with a microphone.
Yeah, I don't know if this is on or not. My name's Alan Zimmerman. Like David, I happen to be a graduate of this law school, and it's always nice to come here and not have to think about passing an exam and all that stuff. So it's always a pleasure now to come. By way of background, I practiced law for 22 years, and then 28 years ago, I founded a company that funds litigation. And I've been involved in funding over 1,800 cases in various courts, including LA County and the appellate courts in California. And I have I'm no longer doing that. I have a tremendous interest in seeing civil justice be improved. I'll leave it at that for now in America. But one of the thoughts I had in listening to your panel, and I have many thoughts, but it occurred to me, I've had an occasion to look for data in various courts all over America for different reasons than just how does a court work, but identifying what's going on. And also had the observation, Your Honor, that this doesn't belong to us, this court system. It doesn't belong to us, the lawyers, and you, the judges. It belongs to the people. That's who's actually paying for this. The taxpayers are paying for this. And we lose sight of that. So one of the thoughts I had, just to pull together the two things I heard from you, you can't go to a doctor, a dentist, get on an airplane, or get any kind of a service in America without getting an email saying, tell us how we did. I'd like you to fill out a survey and say what was your experience and the like. And I don't know why we don't do that. I mean, we're providing a service, the legal services that we provide as lawyers and the courts and the like. Why don't we ask the consumer that's had the experience, how did we do? What can we do to prove? And you get I could think of a million questions I'd want to know if I was running the court system. And I suspect one of the reasons is that they really don't want to know the answer to the question because it's not really working very well. And who wants bad news? But I just think that might be one way to very simply, there's already software to do this. We're not inventing the wheel here to try to do that. Why don't we try to do something like that as one idea, at least, to get some data and inform the court personnel, the judges, and the lawyers, what's going on. And the state courts, as we all know, provide an enormous array of services and and serve an enormous cross-section of the population, from businesses to family law issues and the like, and many in between. And there's a lot to be learned, I think, by doing something like this and maybe identifying what the problems are for people who are trying to use the system and what can we do for openers to try to make it better for them. So that's my thought for the day. But if you spend
There's a project in California called the Sergeant Schreiber Project, which was funded to look at various interventions, representation in critical areas, interventions short of full representation, and to not only provide for that, but to provide for academic research on it. And one of the pieces of that is user surveys. And I think it's been illuminating. The academic pieces that have come out of that are quite lengthy if you've got the stomach for it, but informative. But I think a lot of us believed that users would be happy if they won and unhappy if they lost, and that was as far as it went. There was some work done, some polling done a number of years ago, actually, that said for people who are represented by lawyers, largely they rate the experience as positive or negative depending on the outcome. For people who are not represented by lawyers, their feelings of positive or negativity relate largely to whether they felt they were heard. And I think we need to, I agree with you, we need to let go of our reluctance to ask people what they think of the services, because there is useful information for us to be found. And the experiment in California has shown some of that.
And Alan, I just wanted to add that the State Justice Institute funded someone named Emily Lagrada, who did exactly what you're talking about, put QR codes and iPads in courtrooms in 12 courts across the country, rural, suburban, and urban courts, and just released a report maybe 2 months ago. And it was fascinating, the people who wanted remote court versus in-person court. And it kind of, I think we're just at the tip of understanding and engaging with people. And the National Center, thanks to the generosity of the Pew Charitable Trust, is about to launch some technical assistance around increasing appearance rates in traffic and criminal court. And we're partnering with Emily to do exactly that again in at least 6 more courts. So I'm hoping the field of this will continue to build, but it's a great insight.
And I would just add that the Legal Services Bar has experimented with asking people, what you think of the service we provided? And I think the perception in some offices, I'm thinking some in particular, was that people enjoy the experience and they weren't getting that much meaningful information from that kind of question. And so they've tried to shift it around a little to, well, what did you do? Not, and did it work? Because the legal aid bar sends so many people out with brief advice and brief assistance. And so figuring out if they actually appeared in court and said to the judge what they were instructed to say and then what happened is one way of getting at the efficacy or effectiveness of the service, the brief service that they're providing.
Hi, my name is Alec Webley. My question is, what's sort of an interesting omission in what was discussed was the role of the state attorneys general in the state court system. To give one example, here in New York, the AG has the power to move to engage in mass invalidations of wrongfully granted default judgments and debt actions. That's used usually after they've gone after a shady character and discovered they've gotten 100,000 invalidated bad judgments. So I'm curious, have you experienced worked with or thought about the roles that state AG's offices can play in sort of driving forward thoughtful change in state civil courts?
I would just say that, and there are others in the room, looking at you again, April, who know more about this than I do, but I do think that when you think about access to justice, you think, do people know their rights? Do they assert their rights? Do they get a fair disposition in a court? Can they enforce it? But I do think the movement doesn't often think enough about bad actors in the courts and what can be done through law enforcement. I think a lot of people in the community come from rights protection rather than rights prosecution. And I think but if you look across the country, it's not your grandparents' legal aid organizations anymore. There's an immense amount of collaboration between AG offices, especially here in New York, on employment fairness and wages and overtime, and on debt collection. I know there's work that's been done to categorize the style of enforcement by AG offices of protections for in the context of debt collection. And anyway, there's a lot of work going on. It's a great point. And I think we kind of have to always remember that there are these bad actors. It's not just about your procedural rights. It's about how can we stop people from behaving unlawfully to hurt people.
I'll add to that a couple of things. One is, I think we're in the midst of a lot of attention and a lot of growth in the role that state AGs can play, especially in blue states. States of Democratic AGs, not to over-essentialize. And I think one of the things, echoing what David said, that's happening is that advocacy organizations and legal aid organizations are increasingly seeing that promise and trying to collaborate creatively. And I'm hoping, I don't know what's going to happen on the second panel, but I'm hoping we might talk a little bit more about that, particularly in the consumer debt areas, and employment is another one. I'll also say that actually, One of the things that is just really hard to map in the theme of every state is different is what's the structure in particular states, both in terms of the substantive law that allows for AG enforcement and then just the structure of organizations and the history of state AGs choosing to play this role. And there's actually a forthcoming paper. It's David Knoll at Rutgers Law School and Zach Clopton at Northwestern Law School, where they're trying to map just what are the enforcement powers state by state and what's actually been used. I'm actually not 100% sure if that's someplace coming out or they're still in draft form, but it's a daunting and really important project because I think that then helps us conceptualize, well, to do things differently, what is it we need to do? Is there actually some legislative action to create capacity in different states? Or is this really more political and policy choices by AG's offices to engage that maybe more immediately those of us who care about these issues can have an effect on? Other questions? We're coming to the end, but I want to, yeah.
Hi, my name's Carrie Christ. I'm an IP attorney here in New York, but I'm very interested in family and matrimonial court reform. I was very struck last year by the report that came out by the Fund for Modern Courts and New York City Bar that cited a figure which was pretty astounding, that there were, before COVID, 190,000 cases in the family courts for 56 judges, which prompted emergency action on the part of the Senate. And they basically added 4 judges, which, do the math, I don't think that helps so much. But to your point, Mr. Udell, about data, I don't know how the Fund for Modern Courts in New York City Bar actually got at that data, because in doing research myself, I find it incredibly difficult to find data. And I guess my question is, how is that situation allowed to occur? And how can we address, these kinds of issues? And do any of you know about reforms, particularly in the family courts?
Let's talk about family court.
I can. So I think part of it goes back, not to go back to funding, but the number of judges depends on the state budget allocation for judges. So, that there's a relation there. I want to speak about two interesting innovations that I think we've seen in family law to try to prevent people from having to come to court nearly as much. So perhaps to balance things. In Alaska and several jurisdictions in Washington state, they've implemented informal domestic relations trials, where if both parties are unrepresented, you can waive rules of procedure and evidence and just get straight to the heart of the matter. Again, it's a process simplification mechanism to meet people where they are. And Alaska has also tried an early resolution program, which I'm extremely excited about. It's been going on probably 10 years now, where if both sides are unrepresented, they get a letter and then a phone call from court staff encouraging them to come. It's like getting the golden ticket in Willy Wonka, and you can come to court. And you can, you either each party gets assigned a lawyer, or they get assigned a mediator or the judge. And that day, there's a real attempt to solve most of the issues that can be resolved that day, so that if there is anything left, it can be done. You're really kind of triaging what needs to happen in the court system. And they've been enormously successful in Alaska in kind of peeling off cases and also preventing the parties from entrenching their positions as it goes longer and longer on, which I think is to the benefit of everyone. So those are just two kind of structural ideas that I would suggest.
I would just add that there's a need for tech improvement on your question had a sort of data part, as well as just the focus on the disparity between the number of cases and number of judges. But on the data part, some courts still use mainframe computers. And I said that to a tech friend of mine who said, well, mainframe computers have a lot of capacity. You shouldn't just denigrate them. And so things like the Fund for Modern Courts, I don't know where they got their particular data, but a lot of courts have the capacity to generate reports over a period of like 3 days or 7 days in order to figure out more about the case volume that they have. We've encouraged through the Justice making case counts public, like posting them on the court website so that we can react to situations like this where there's an overwhelming volume of matters and so few people to handle it. So.
Other questions or thoughts before we thank our panel for today? Well, thank you, everyone.
I'll give one,
David.
since we've got 5 minutes left, no one else does. David, you mentioned, so I'm David Siffer, I'm the research director at CCJ. So David, you mentioned the court simplification process in New York. And I know that I've had a lot of conversations with a lot of people in this room about that, Jim and Alex and Martin. I feel like it's a complicated, so I feel like there's been a lot of back and forth about the court merger, court simplification, about the advantages and disadvantages, the advantages of having lots of specialized courts, maybe disadvantages in terms of access to data, advantages in terms of different access points to become a judge, disadvantages in terms of, confusion potentially caused. Do you have thoughts on, is it good or bad? Is there a way to get the best of both worlds?
So I'd probably turn it over to Danielle, who lives and breathes court structure kinds of questions. I don't, I look as an outsider. But in the simplification, sometimes we think about what Danielle was speaking about in terms of simplified court forms and easier ways for people to interact with courts. But I think on the focus on unification, I'm not sure I have much more to add to what I said earlier. If it were done my way on a blank slate, I'd probably want to have top-down massive control. Not everybody likes that. We do have a system in the United States that fosters independence and autonomy and experimentation. I guess the points I wanted to make were that I think we can make a new run at least knowing what's going on across the system, even in a decentralized system, now that we have better work options available to us with technology, communication, and websites. But Danielle, I'd turn the deeper questions over to you.
I don't have that much more to add. I would say I'm a fan of centralization and unification for efficiency purposes. It's like having a fire department in every municipality versus kind of streamlining things. So I think for cohesion and more efficient management, I'm a fan of it generally.
Team spirit.
Have other states had the problem that New York's had where, a centralized court system has been, maybe punitive towards judges that haven't issued rulings that they like and reassign judges in ways that are, oftentimes quite political? Is that a problem elsewhere? Is that just a New York specific one?
I think you can
There
see
are
that-
political stories in many, if not every state.
What I would.
I was just gonna say, I would say, David, your question kind of gets at some different layers, and I think it's important to be clear about what we're aiming for. I think the structural question of sort of how control is implemented in a court system and how bureaucratically it's organized, what I hear David Udell and Danielle saying is, they're in terms of information gathering and understanding what's going on in communication, and there's a lot of advantage to centralization. That's different than should every judge be doing things the same way. And so in that sense, specialization can be a different conversation. I think there are a lot of examples of specializing courts and the leeway and constraints we place by written law or by practice on particular judges. And that's not inconsistent with a centralized court system. So those are different layers of the question.
I would add only that I think you put the question sensitively and understanding that there's a tug, about these things. It reminds me of the debate about private sector versus government administration of certain functions. And I think these are like iconic, tensions, and sometimes government becomes ossified and petrified and you want the private sector to do certain things. And I think there are real virtues to decentralized courts, but accountability to sort of basic expectations and norms about how to interact with the public, I think you do better with statewide authority.
Just in 2 really quick points. One, I think to Justice's point earlier, one of the benefits of having maybe some of this independence is that you can get experimentation, right? This laboratories idea. I think the problem is, right, in Georgia, we have 159 counties. second only to Texas, and we're much smaller. So that means there's 159 different ways of doing things. And even if some county is doing something really innovative or interesting, there aren't really great systems in place for actually communicating that and sharing that information within the state or probably, beyond. So I think to the extent that there is this benefit, trying to figure out, is there a way to at least take advantage, harness that benefit in a better way? And to Colleen's point, right, this sort of one size fits all. I think part of the challenge is thinking about, right, at least trying to cast certain principles or ideas of reform at a high enough level that you can figure out how to adapt that to places that are really different, right? And again, as someone who spends time in rural courts and also in a state that is very different from New York, I think a lot of times it's hard when you see things coming out and just sort of feel like that there are so many ways that won't fit here, but I suspect that there's some level of generalization, right? That is just a question of translating to that jurisdiction.
And with that, thank you everyone for joining us today.
Thank you.